contracts in the electronics age. This meeting is being recorded in case you would like to watch it again later or for the benefit of your classmates who couldn't be here. So this week, no discussion forum. All we have is this assignment, written assignment, cheating the elderly. No quiz either, so that's good. We do have a quiz module 6. So fall term 1 does end on Tuesday, November 8th, which is election day. So this is going to be the last live session that we have synchronously, which means at the same time. So next week, the module 6 live lecture will be a pre-recording, probably from last year or last semester. And I'll post that and make it available to you on Sunday, because module 6 is very short. It's like Monday, Tuesday, and Tuesday is the last day of class. And there is a quiz and a written assignment. So you'll have that live session video. And if you follow my YouTube channel, the module 6 live session is already on there, so you can get it there and watch it at any time. So this is our last live session in real time. We're going to talk about contracts in the electronics age, which is very interesting. We're also going to talk about some challenges to enforcing a contract. So we started out this term, which has flown by, with the 3 elements of a valid contract. What are those 3 elements again, Abby?
Isn't it offer, acceptance, consideration?
You got it.
Okay. I always
Great.
second guess myself when I'm on the spot.
Yep, good practice. So yes, you got it. Offer, acceptance, and consideration is all the court needs to find a valid contract. Certain agreements, though, will not be enforced in a court of law. One is if the person who is entered into the contract lacks the capacity to contract. One reason why someone might lack the capacity to contract is because they're too young, a minor. So if a 16-year-old goes to buy a Ferrari on his 16th birthday, that contract can be voided by him or his parents because he lacks the capacity to contract. Now, they could affirm the contract, make payments on the car, and then he would own the car, but that's voidable. So an agreement entered into by someone who lacks the capacity to contract is voidable, which means able to be voided. So someone who is insane, the contract can be voided. Someone who is intoxicated, somebody might be in a bar drunk and offer to sell their house for $1. Because they're intoxicated, they lack the capacity to contract. That contract can be avoided. So there is a difference when it comes to insanity. If somebody has been determined insane by a judge, they've already been through a mental competency hearing, and the judge has already said, you are insane. The contract is completely void. Nobody can enforce it. If the person is insane, determined by a doctor or a medical expert, but a judge has never adjudicated them insane, then the contract can be voided by the insane person. It's always the person who lacks the capacity to contract, Joe. They're the ones who can avoid the contract. The person who was totally sane cannot void the contract because they had the capacity to contract. Okay. We talked about intoxication. Legality. Okay. Now we're talking about contracts that are void from the beginning. A contract that is illegal would be void from the beginning. An example would be a contract for murder. Again, if you watch any of these true crime shows, or I just saw it in the newspaper today, people are constantly killing their spouses or hiring someone to do it. A contract for hire to kill your spouse is illegal. that means that contract cannot be enforced. So if the gunman actually goes and shoots your husband, and then you don't pay him the $10,000, that's the going rate to hire a hitman. So it's about $10,000. He cannot go into court and claim breach of contract. Say, Your Honor, I killed her husband, but she never paid me. The judge will say that was an illegal bargain and it is void. So void means that it is unenforceable and it was void from the beginning because it is illegal. Probably a contract for the sale of gambling machines in a state where gambling is illegal. Trying to think of a state where gambling is illegal. Utah. Okay, so a contract to build a casino in Utah, that would be void. It has no legal effect at all because the subject matter is illegal. Another would be a contract for a loan with an interest rate that exceeds state law. Most states will not allow a loan that is more than 10% interest. They call that usury laws. So anytime a consumer has been hit with a loan that is more than 10% or whatever the state determines, again, it goes back to the Constitution. Um, the 10th Amendment says any powers not expressly given to the federal government are reserved to the states. That's how the state has the authority to police. The state has the authority to come up with laws against crime. The state has the authority to regulate healthcare, COVID restrictions. The state has the authority to determine the legal interest rate. That's because of the 10th Amendment. Any powers not expressly given to the federal government are reserved to the states and the people. So, usury, a contract for a loan with a 20% interest rate, that violates consumer protection laws and it's against the usury laws. That's void. Anything that's an illegal bargain is void. A contract for the distribution of alcohol during prohibition, that's void. Any questions about an illegal bargain? Excellent. This is, I always think, very interesting. I used to do construction law out in San Diego. A lot of times, anytime you have a development, which these days there's constant construction, building developments, you usually have a owner of the property who hires a general contractor who hires a lot of subcontractors to get work done. The subcontractor might be in charge
I
of,
just
hi,
calling you
hi,
and you
Shayna.
like this. Oh, you
The
can't
Can you put yourself on mute, Shayna? So when you have
say
a
what?
development project, let's see if I have the mute
Okay.
button here. Can you mute yourself?
I know what's wrong. Want me to text it to you?
Mute. Okay, she's not talking right now. There used to be an option where you could mute
I
everybody.
just called you. That's why I just called you and it went to voicemail. And I didn't know you called me right back. I was thinking you had to charge your phone.
Don't see the mute option. Like I was saying, so when you have a construction project, you have an owner, you have a general contractor, and then you have numerous subcontractors. If that general contractor does not have the license, for example, Texas requires that contractors all be licensed. So if a contractor performs work on a construction project and that contractor is not licensed, then the contractor cannot be paid under the contract. Okay.
What was the count?
Okay, here's another type of contract that is void. It is an unconscionable contract. Again, back to the U.S. Constitution. That's why it's very important who is interpreting the Constitution. The U.S. Constitution says no state shall impair the obligation of contract. So we have a constitutional right to contract. However, if the contract is very oppressive to the consumer because it has like balloon payments in it, or it's an installment contract and it has a lot of waivers of liability and tiny print and font and interest rates that you can't even see. I remember when I got out of college and I got a job in Colorado, I rented some furniture. It was rent to own. That rent to own agreement had tiny font on it. If the consumer is waiving a right to bring a lawsuit, waiving a right to file a personal injury suit, um, sometimes the court will say that that agreement is unconscionable, or if it's so unfair, if the terms are so unfair that it's oppressive, it will be seen as unconscionable and the court will refuse to enforce it. A lot of companies will try to waive their own liability for tort injuries. A waiver of liability is disfavored in the law. So, for example, every Ford that I've ever owned has been recalled. I just got a recall notice yesterday on my car. I'm not going to take it in because it takes way too long. It was something very small. So, but every Ford I've ever owned has been recalled. If Ford tried to put a waiver of liability in the purchase agreement, where they say, you know, Catherine, if you get into a car accident, you can't sue us for products liability or a defective car or defective design, the court would say that is unconscionable. It's simply unconscionable. And actually, I purchased a Ford once in Colorado. When the bank looked at the paperwork, they said there is a $5,000 extended warranty that's been added on to this. Did she know? Did the customer know? The bank said, we refuse to sign off on this car, the Ford that Catherine's purchasing, because there's been a $5,000 extended warranty put on this, and we think that's unconscionable. So, you know, I'd already taken the car home. Ford called me back. They said, can you come back to the dealership? And they said, you know, blah, blah, blah. We're going to have to, you know, take this $5,000 extended warranty off. And I'm like, gee, I'm glad somebody was looking out for the consumer, you know. So those type of things are unconscionable, and the court will not enforce an agreement. One way that the court may try to handle the situation is to strike a particular clause or a provision in the agreement and go ahead and uphold the contract, or the court may throw the entire contract out. Here is the test to determine whether a contract or a provision in a contract is unconscionable. The parties possess severely unequal bargaining power. One is the rich dealership, one is the poor consumer. That's an unequal bargaining power. The dominant party unreasonably used its unequal bargaining power to oppressively or manifestly put unfair contract terms, like that $5,000 extended warranty that I didn't want. Adhering party had no reasonable alternative. I just signed the contract because I needed a new car. So I think that was, you know, that $5,000 extended warranty was unconscionable. And I'm glad that the bank realized that when they were looking over the agreement. So that's the test for unconscionability. Let's talk about e-commerce. So the use of the internet and the World Wide Web and the sale of goods through e-commerce has exploded. It's simply wonderful that back in the 1990s, Jeff Bezos was sitting in his garage in California with a very antiquated computer, and he had written the word Amazon on a piece of notebook paper. That's all he had in the 1990s. By 2000, though, he was ready to, you know, go public with his company, Amazon. And thank goodness, because when the pandemic rolled around and it was difficult for people to get out of their house because we were under lockdown, we were able to get on Amazon and shop. So e-commerce has exploded. There was a period of time when I could quit teaching. I think it was around 2010. It was before I started teaching here. I had just taken a break from teaching. And I decided to start a store on Amazon. It was called Kathy's Corner. And I had one on eBay also. And people will buy anything, especially at that time. You could put anything on eBay, a chocolate covered roach. People would bid on it on eBay. Some of my coworkers used to just sit there at work and get into bidding wars, bidding over,
Mhm.
little Betty Crocker knickknacks and things they remember when they were kids, and Barbie summer home, because they either had a Barbie summer home when they were kids or always wanted one. They would just sit there and bid on stuff like that all day. Or some of my coworkers would take their used golf clubs and sell those on eBay. I'm like, why would I want the dirt off of your golf club in my house? People will buy anything on eBay and get into a bidding war over it because of the competition. So I found that to be, a great way for me to get into e-commerce is to have, these online storefronts. It was very, very easy. So, contracts can be created via email, electronically, e-contracts or electronically made agreements that are enforceable in court as ordinary oral or written contracts. Again, if it's a contract for the sale of goods over $500, what applies, Joe? What would apply to a contract for the sale of goods over $500?
I'm sorry? What would apply?
What type of law applies to a contract for the sale of goods over $500? Do you know what it is, Abby?
Is it common law?
Mm-mm. Contract for the sale of goods flowing freely through commerce across state lines.
UCC.
Perfect. So the UCC actually
UCC.
relaxes the rules for offer, acceptance, and consideration. There is no mirror image rule in the UCC. The purpose of the UCC is just to really try to uphold commercial agreements. So when you purchase something on the internet, e-commerce, if it's over $500, the Uniform Commercial Code applies. Offer and acceptance is much easier to prove. There's no mirror image rule. There's no real, the courts are much more relaxed about enforcing those agreements because it's very important to our economy that these electronic and these interstate contracts be enforced. So that's the purpose of the UCC, is to make it easier to enforce a contract, to know what the parties' duties are and what their remedies are. So contract for the sale of goods over $500, if it's done online, the UCC still applies. What I found interesting during the pandemic is sometimes I would get on Walmart's site. I wanted to buy an air purifier because they were saying if you have an air purifier, that can kill some of the COVID virus. So I said, I'm going to buy some air purifiers. Well, I got on Walmart.com and bought this air purifier. And I said, if I don't like it, I'll return it. Once I got it, I realized it was not sold by Walmart. It was sold by some other individual who had their company listed on Walmart. The same way Amazon had Kathy's Corner, or the way that Amazon lists a bunch of different sellers, people in their private houses, people who own businesses. They're listing their products. Very rarely are you buying something from Amazon unless it says fulfillment by Amazon. So the same thing with Walmart.com. You're not buying it from Walmart unless it says so. You're buying it from some private seller who lists on Walmart.com. So I realized I bought an air purifier from someone who was listing on Walmart.com, and I wanted to return it. I was stuck with it, and I still have that air purifier. It's okay. It was just really, really techy and very, very hard to program. So it's something to be aware of, that a consumer may not even know who you're really buying from when you purchase something on the internet. Let's talk about warranties. A warranty is a promise that a product is fit and will be repaired if it is not fit. The UCC has certain warranties, and there are many warranties at common law. These are the common law warranties. Express warranty means that the label of the product should say what it is. The product should be what the seller says it is. If you buy a car or you buy a shirt, there's an express warranty that that you're buying what you think you're buying. So when the parties agree to something, if you go in and buy a lawnmower and you're talking to the salesperson, hey, I'm buying a lawnmower. Yeah, there's an express warranty that that's really a lawnmower and that it's going to do what lawnmowers do. Now, there is an implied warranty of fitness for ordinary use. That's called also the implied warranty of merchantability. That means that a seller guarantees that the product does what a product of its type normally does. You do not have to express that. An express warranty is one that is stated between the customer and the merchant. The customer and the salesperson state it. It's expressed. The implied warranty means that anytime you purchase a product in the store, there's an implied warranty that it is fit for ordinary use and that if you buy a toaster, it is not going to explode that night while you're watching TV. Okay. That's the implied warranty of merchantability. And if you buy a toaster and it explodes that night, that is a violation and a breach of warranty. So you have a lawsuit, you call an attorney, you file a lawsuit for breach of warranty of merchantability, which is the same thing as breach of warranty of fitness for ordinary use. If you buy a refrigerator and it blows up, that is not what a consumer expects a refrigerator to do. That's breach of the implied warranty of merchantability, which is the same thing as the breach of warranty of fitness for ordinary use. The other warranty is his fitness for a specific purpose. So if the customer goes into the store and says, I'm buying a bed because my kids like to jump up and down on it, and the salesperson says, yeah, this bed is good for kids to jump up and down on it. Well, that's the, now you're talking about for a specific purpose. So if the seller has reasons to know and understands the purpose of the buyer, if the seller and buyer are both businesses, a contract might be made specifying the purpose. So there is an implied warranty of fitness for a specific purpose, so long as the seller knows what the buyer's buying for. And anytime somebody produces a product, foreseeable misuse is they're held to the standard of foreseeable misuse. When you sell a bed, you know some kids are going to jump up and down on it, right? If you ever watch Instagram, you can see celebrities at home with their kids and they're jumping up and down on that bed. Have you ever seen that? I was looking at Instagram a lot during lockdown and the pandemic, and I was like, look at all these celebrities at home jumping up and down there with their bed with their kids. So the manufacturer of the bed knows that people jump up and down on the bed, and they had better make it sturdy enough for that specific purpose because ordinary misuse is foreseeable. So these are some of the warranties that a seller and a manufacturer and a merchant are going to be held to. They're promising that the product is fit for its ordinary use and for a specific purpose if the seller knows what that specific purpose is. Any questions? That will definitely be on your module 6, then the quiz next week. It's a myth that businesses ever want to give you more warranties. They customarily try to limit the warranties. This is because warranties are already set by state law. The standard ones set by law can be excluded or limited unless the limitation is prohibited by consumer protection laws. A business may totally exclude the warranty of merchantability. However, the court's not going to uphold that. UCC 2-316 requires that an exclusion of the warranty of merchantability, that's fitness for ordinary use, has to mention merchantability and be conspicuous. It has to be in bold, in caps, and in large typeface. Unless it is not effective. So it's very difficult for a business to exclude the warranty of merchantability. They would have to do that in writing, and it would have to be conspicuous and in a way that the customer could see that in their agreement, their contract, their paperwork. So be sure to complete that knowledge check in Module 5 on warranties before taking the quiz next week, because it's on there. Any questions before we get to our Module 5 assignment? This is a great scenario. It's very realistic, and it's one that you could actually see when you're working as a paralegal. It's called cheating the elderly. Many law firms do handle estates and trusts, and family trusts, and they, work on these type of wills and trust cases. In this scenario, grandpa has dementia. He's getting older. His grandchildren want to help him out, but they want to be paid for it. They want to get his salary from his Social Security and his 401k, and they want to get $50,000 at the end of the year to help him out. And if he should outlive his assets, they want him to go on Medicaid and assisted living at state expense. So his grandchildren, Johann and Mary, they want to inherit his assets, but they may be accused of elder abuse or cheating the elderly. So they hire an attorney, your supervising attorney, to prepare a contract for grandpa to sign. It says his grandchildren will do normal weekly housekeeping. They'll look in on grandpa at least 3 times a week and return for the remaining funds payable over a 3-year period. They will not do any personal care, though. You'd be surprised how many caretakers refuse to bathe the elderly. It's terrible. So they don't want to do any personal care. They're just going to look in on grandpa probably and order DoorDash. They're not going to do anything personal. So should an attorney take on this case? Is grandpa of sound mind? Does he have the capacity to contract? He's got dementia. So what do you think about this case, Joe?
No, I mean, for him having dementia, he's not in his right mind to understand the contract, much less sign it.
Yes. So when you're doing research this week, Joe, you'll want to see if you can find a case that says dementia means that a person lacks the capacity to contract. So here's the research that you need to do, and it's in order. Number 1, find the very latest case on Lexis Advance or Fast Case. Using a search like voidable contracts and incapacity, you want to put voidable contracts in quotations so that you'll find that term, and that focuses your search. So find and cite the most recent case on contract law and undue influence. Do not cite a criminal case. I've had a handful of people in here citing criminal cases. Contracts is civil law. We're not citing criminal law for any purpose. That is not on point. You can even put not crim asterisk to avoid cases like that coming up in your search. So take a position on the 2 issues. The first issue is fraud or incapacity involved in this contract between Jacob and his grandkids. That gets an IRAC. Issue, rule, analysis, conclusion. You write that yourself. You have a second issue to IRAC. If the attorney does the contract, no one reviews it for Jacob. Is that ethical under the ABA Model Code or the ABA Rules of Professional Responsibility? That's your second issue to IRAC. That's the issue. You find the rule from the cases. You analyze the situation with Jacob and his grandkids, and you reach a conclusion about Jacob and his grandkids. Do not IRAC the cases you research. You do not have to IRAC the cases you research. This assignment is about application. So you're taking your ideas, doing 2 IRACs. The first issue is fraud or incapacity involved. You can get the rules from the cases or from this lecture or from the textbook. You'll be doing an analysis of whether fraud or incapacity is involved with Jacob. Second issue that you IRAC. Is it unethical for the attorney to represent Jacob's grandkids and him not have any legal counsel in this case? What's the rule? You'll want to cite to one of those ABA model rules or a court case that you find on Lexis, and then analyze whether an attorney should be taking this case at all. Reach your conclusion. So this is a position paper. You take your own position, you do your own IRAC, don't IRAC the cases. And finally, 7, identify your ideas on what the other side may say in response to their position. It's always good to understand what the other party may say. In fact, there is an ethical obligation for attorneys and paralegals to be aware of and bring to the court's attention any relevant cases that support the other party's position. Can you believe that? There is an ethical obligation for attorneys and paralegals to look at the judicial precedents that can help the other side and to bring that to the court's attention. So that's why the assignment's asking you, what would the other side argue? It's your ethical obligation to know if the other side has a valid argument in their favor and to bring that case to court and give it to the judge. So any questions about this assignment on cheating the elderly? I think it's going to be a fun assignment, Joe, Shayna, and Abby, because it does let you take your own position. Well, Tuesday is our last day of class. Let's cover our end of term reminders. Module 5 will end on Sunday, November 6th. Your live session question this week: what is the implied warranty of merchantability? Type it into that live session answer box. And again, that question will be on your Module 6 quiz. Module 6 begins on Monday, ends on Tuesday. Very short week. You have a written assignment and a quiz. I will release on Sunday your live session video and quiz review. If you're already subscribed to my YouTube channel, the live session for Module 6 is already there. Fall term 1, can't believe it. It's been a great term with you all. Ends on Tuesday, November 8th, Election Day. No assignments can be accepted for grade after the term ends. We finished 5 minutes early. Any questions, Shayna, Abby, or Joe?
No.
Not at this time, not that I can think of. I thank you so much, and I really enjoyed this class. Thank you.
Oh, you're welcome. It's my pleasure.
Yeah,
Contracts
had a
is
good-
fun. Go ahead, Joe.
I had a good with this class. I mean, with just being able to speak with you and everything, it was a really good class. Thank you.
You're welcome. Yes, Rasmussen. I'm glad that you liked it. Rasmussen is one of the few universities that likes to keep this live lecture going because we realize that there's a lot of people that benefit from this type of learning style, the interaction, the audio visual. I would have needed this when I was in law school. I need to see the professor. I need to talk to the professor. I'm a very social and interactive person. I mean, when I graduated college, I'm not kidding, 10 years later, I was still talking to some of my professors. So yeah, I need to see the teacher. I need to hear it from the horse's mouth. I need to be able to, interact. And I taught in the classroom for over 10 years before I started teaching online for Rasmussen. So I like to keep that oral tradition going. Human interaction is very important, even in the digital world, even in an era of COVID, in an era of artificial intelligence and robots. Human interaction is very important, and we all need it. And, and it's valuable for me too. So I just appreciate you ladies making the effort to attend your weekly live sessions, and definitely on average, the students who attend the live session get better grades because you're hearing it from the horse's mouth. So I'm glad you enjoyed it. And please feel free to fill out your student survey at the end of the term. Any thoughts, feedback you have on the course is always appreciated. The university, looks over all of those. They're totally anonymous, so please feel free to fill out your student surveys. And have a great weekend, everybody. My e-door is always open. If you have any questions, I'm just an email or a phone call away.
Thank you.
Bye,
Thank
Joe.
you
Bye,
for
Abby.
everything.
You're welcome. See you later.
Bye.